AI errors in court. A wake-up call for judges? Imagine a future where artificial intelligence, AI, plays a pivotal role in deciding legal battles. It's a scenario that's not as far-fetched as it may seem, and it's one that has experts concerned. In a recent incident, a Court of Appeals judge in Georgia, Jeff Watkins, shed light on a potential AI-generated order that could set a dangerous precedent. The order, which was drafted by a lawyer named Diana Lynch, relied on fake AI-generated case citations to support its ruling. This has sparked a crucial conversation about the role of AI in our legal system and the potential consequences if judges fail to recognize and address AI errors. The implications of this incident are far-reaching, especially considering the overwhelming caseloads that many lower courts face. Experts warn that judges overlooking AI hallucinations in court filings could become a common occurrence, leading to a breakdown of trust in the justice system. So, what can be done to prevent such scenarios? Some states, like Michigan and West Virginia, have taken a proactive approach by issuing judicial ethics opinions that require judges to be tech competent when it comes to AI. This means judges must stay updated with the latest advancements in AI technology and understand its potential impact on legal proceedings. However, not all judges are prepared to embrace AI without proper guidance. Some have banned its use altogether, while others have implemented disclosure requirements, demanding to know which specific AI tools were utilized. The challenge lies in finding a balance between embracing technological advancements and maintaining the integrity of our legal system. As AI becomes increasingly embedded in popular legal tools, it may become increasingly difficult for lawyers to discern whether they've used generative AI. This is where education and ethical guidance come into play. Judges need to be equipped with the knowledge and tools to navigate the many pitfalls of AI, including biases, evidentiary challenges, and the potential for AI hallucinations. One proposed solution is the development of an open, free centralized repository of case law. This would make it easier for judges, lawyers, and the public to verify the authenticity of AI-generated citations. It would also provide a transparent and accessible resource for all stakeholders involved in the legal process. Additionally, task forces have been set up in several states to monitor regional court systems and provide AI guidance. States like Virginia and Montana have even passed laws requiring human oversight for any AI systems used in criminal justice decisions. While these measures are a step in the right direction, the journey towards responsible AI integration in our legal system is far from over. It requires ongoing education, collaboration, and a commitment to ensuring that AI enhances, rather than undermines, the integrity of our justice system. As we navigate this complex landscape, one thing is clear: the role of judges in maintaining the rule of law and upholding justice is more crucial than ever. What are your thoughts on the potential impact of AI in our legal system? Do you think judges are prepared to handle the challenges that come with AI integration? Share your insights and let's spark a conversation about this critical issue. AI hallucinations in legal cases. What you need to know. AI in the courtroom. When technology trips up justice. Imagine trusting technology to help you win a legal argument, only to have it undermine your case instead. That's exactly what happened in a recent, headline-making intellectual property dispute. ProHealth Solutions Limited v ProHealth Inc., 2025, 6WL UK 622. But here's where it gets controversial. The case exposes a growing, and somewhat alarming, trend: lawyers and litigants relying on artificial intelligence tools like ChatGPT to prepare crucial legal arguments. Are we too quick to trust the machines with something as critical as the law? The dispute, ruled on June 20, 2025, by the appointed person, AP, in the UK's Trademarks Registry, revolved around trademark registrations and efforts to invalidate certain marks. The appellant, representing himself, appealed rulings that had favoured ProHealth Incorporated. While this appeal was ultimately dismissed, The real story lies in how the case was argued, and what went wrong. Here's the part most people miss. The appellant openly admitted to using ChatGPT to generate both his grounds for appeal and his supporting arguments. Sure, the cases he cited were real, but many of the quotations and synopses he included did not actually appear in those judgments or, worse, misrepresented the core rulings. When the errors came to light, he was upfront about his mistake and issued an apology. The respondent, who had the backing of a trademark attorney, didn't escape criticism either. All the cited cases in his argument were authentic and properly referenced, but he struggled to pinpoint exactly where those cases backed up his legal claims. Even after the hearing, he failed to clarify these connections in follow-up correspondence. This raises a provocative question. Is it enough to cite real cases, or must every reference be backed by a clear, direct link to your point? How much responsibility should legal professionals bear for weak citations versus outright fabrications? AI hallucinations. A legal minefield. If you think this is a rare blunder, think again. As flagged by experts like Fiona from Lewis Silken, AI-driven errors, often called hallucinations, are surfacing more often in courtrooms. These hallucinations occur when AI tools generate information or quotations that appear plausible but are, in fact, invented. Sanctions are already being considered, and sometimes enforced, against those who mislead the court, intentionally or not. For example, the high-profile Frederick Ain v. the London Borough of Haringey, 2025, IWHC 1040, admin, case was specifically referenced in this dispute, as it highlighted just how easily AI can trip up even the most well-meaning legal professionals. The AP in this case made an important distinction. Honest mistakes differ from submitting altogether fictitious legal authorities. Still, regardless of your experience or whether you have legal counsel, everyone bears a strict responsibility, not to mislead the tribunal, whether through ignorance or by submitting AI-generated fabrications. And this is the part most people miss. Even accidental misrepresentations can blur important distinctions and risk severe consequences. There's a twist, though. Despite the mix-ups on both sides, neither party received sanctions this time. The respondent's attorney, however, came dangerously close to a formal referral to the Intellectual Property Regulation Board, IPReg. Instead of punishment, the AP recommended a strategic change. The UK Trademarks Registry should include robust, unambiguous warnings whenever they request legal submissions, arguments, or other documents. These would spell out the dangers of using AI-generated research for legal drafting and make it clear that presenting fabricated citations could have serious repercussions. What you need to know. For most people, stumbling into a situation where AI-generated content leads you astray is a nightmare scenario. However, don't panic. This case isn't a call to abandon technology entirely. Rather, it serves as a powerful reminder. AI, no matter how advanced, still can't replace thorough, reliable legal research by a trained professional. Human expertise is irreplaceable when accuracy and trust are on the line. Looking ahead, we'll be watching to see if the registrar acts on the AP's suggestion for clearer guidance and warnings about AI use, in England and perhaps beyond. So here's the question for you. Should legal professionals be barred from using AI tools like ChatGPT unless every output is meticulously verified? Or is this just one more tool, like early spell checkers or research databases, that the profession must learn to navigate with care? Where do you draw the line between innovation and reckless over-reliance? Share your take in the comments. Debate is not only welcomed, it's needed. Note: this article is intended only as a general overview. For advice on specific circumstances, please consult a qualified legal expert. South Africa drafts AI policy to combat fake case law in legal system. In a groundbreaking move, South Africa's Legal Practice Council, LPC, is crafting an artificial intelligence, AI, policy to oversee the integration of AI technology within the legal profession. This development comes hot on the heels of two high-profile court cases that rocked the legal community, where fictitious case law, generated by AI systems, was presented as legitimate precedent. The cases, Movendleller v. KZN-MEC for Cooperative Governance and Northbound Processing v. SA Diamond Regulator, triggered an investigation by the LPC when legal professionals submitted fabricated judgments as part of their court filings. The LPC, tasked with overseeing attorneys, advocates, and aspiring legal minds, views such actions as a grave misconduct. According to LPC Deputy Chair Llewellyn Curlewis, this situation has the potential to severely damage the credibility of our justice system. Every piece of AI-generated content must undergo rigorous verification prior to inclusion in legal documents. The LPC is currently collaborating with industry experts and IT professionals to formulate comprehensive guidelines that can be enforced. Despite the novelty and complexity of AI regulation, Curlewis asserts that even inadvertent misuse will be met with strict disciplinary measures, potentially leading to disbarment. Given South Africa's legal system's heavy reliance on precedent, the misuse of AI poses a significant threat. Recognizing the challenges faced by academic institutions in maintaining assessment and research integrity in the era of generative AI, the LPC intends to leverage their insights in shaping its policy. Higher education establishments confront these issues on a daily basis, Curlewis observes. Their experiences will be invaluable in guiding our strategy. The AI policy is designed to strike a balance between fostering innovation and upholding ethical standards in legal practice. Its primary objective is to ensure that emerging technologies do not undermine public confidence in the rule of law. But here's where it gets controversial. How will the LPC differentiate between intentional and unintentional misuse of AI? And this is the part most people miss. Will the new policy inadvertently stifle technological advancements in the legal sector? We invite you to share your thoughts. Do you believe that strict regulations are necessary to curb the misuse of AI in legal proceedings, or could they potentially hinder progress? Let us know in the comments section below.